Good afternoon, Professor Mkansi.
Good afternoon, Chief Justice.
Let me just make you, are you only doctor or professor as well?
I'm the only doctor, unfortunately not a professor.
Okay.
Yes.
For how many years did you serve as magistrate, district court magistrate?
District Court Magistrate for over 10 years and Regional Magistrate for 5 years.
And prosecutor?
Prosecution, it was from 1997 until, I believe, 2002, 2003, because it includes as a district prosecutor, as a regional prosecutor, and as a senior state advocate for specialized commercial crime unit, the first ever specialized commercial crime unit in the country, in Pretoria.
Now, have you acted as a judge?
No, I haven't.
But you've been a magistrate.
I've been a magistrate.
Did you focus only on criminal matters, or did you get involved when civil jurisdiction was introduced in the regional court and do civil matters as well?
I had an opportunity to do civil. From the time I was a district magistrate, I'm the current chief magistrate of Pretoria, Mr. Desmond Naya, offered me an opportunity to serve in the district court for over 5 years. And when the civil jurisdiction was introduced in the regional court, I attended training, and I have dealt with civil matters, civil applications, opposed, unopposed, civil trials, and divorces.
And do you think there is a major or a minor difference between the responsibilities of a regional court magistrate and a high court judge? In other words, do you anticipate challenges if appointed to the high court, or not really?
Honestly, Honorable Chief Justice, there isn't much of a difference. With the exception in criminal and the regional court, when we talk of criminal cases, with the exception of high treason, regional magistrates, we deal with all serious offenses: your rape, your murder, your robbery. A regional magistrate can impose life sentence. I have imposed a couple of them, especially when I was doing sexual offenses in Bloemfontein for the first 3 years.
So you don't think it'll pose a significant challenge to you to be appointed a high court judge without having first familiarized yourself with that environment?
Not at all, Honorable Chief Justice.
Yes.
With the exception of your reviews, your appeals, the fact that in the High Court, judges have inherent jurisdiction, the rest is the same. In fact, in terms of the Judicial Service Guidelines adopted on the 10th of September 2010, 18 experience as a judge is not a prerequisite. The guidelines provide 3 primary considerations. The first one is appropriately qualified, which I believe I am. Secondly, fit and proper, which I believe I am. And thirdly, Section 1742 of the Constitution, which is a reflection of race and gender composition. It further provides supplementary guidelines, amongst others. It's whether a potential appointee, whether an appointee has potential, energy and motivation, competency, symbolism, as well as integrity. 5 of them, extra 5 of them. I believe I meet all these criterion.
Yes. Have you attended any of the aspirant judges programs offered by the South African Judicial Education Institute?
I did, and fortunately, the aspirant judges training, which was held outside Kempton Park, the opening speech was given by you, Honorable Chief Justice. I was part of that. I also attended the advanced one. The convener was Justice Majid. So
Yes.
I attended both of them.
Yes, yes. Judge President Lope.
Thank you very much, Chief Justice. Good afternoon, Doctor.
Good afternoon, Judge President Trope.
Tell me about your PhD. What was it on?
My PhD was on plea bargaining, Section 105, capital A, before it became
It was on criminal law. Thank you. Was your thesis published?
my thesis was published by UNISA, by the university.
Okay, internally.
Yes.
Fine, thank you. Professor, we run courts differently.
He is just doctor, he's not professor.
Oh, sorry, Chief Justice. Doctor, I apologize. Different courts are run differently in South Africa by different heads of court. I'm talking about high courts. Normally in the Western Cape, which is the court over, which is my court, I invite acting judges to come and act. I would give you a lot of time to prove your worth, expose you to a variety of different kinds of work, including motion court, opposed, unopposed, trials, and so on. After a while, it can be 3, 4, or even longer in terms of acting stints. Then I would encourage you to apply for a permanent appointment. You have not gone through that.
That's correct, Honorable JP.
Thank you. I know Judge President Mlambo does exactly the same thing. The question is this, sir. Have you ever been invited by Judge Mlambo or any other judge president in this country to take up an acting position on the High Court?
Honestly, Honorable JP, I haven't.
Thank you.
But I must point, sorry?
Sorry, sir, carry on.
Yes, I must point out that I have applied to more than 5 JPs asking for acting appointment. I've done so.
Right. In the Cape High Court, 35% of the work is criminal law, and as high as 65% is civil law. How do you think you would cope, given that you have not acted in the High Court, and given that a very large percentage of work is in fact civil work?
Honorable JP, I have an all-round experience. Let me elaborate a little bit. I was an attorney in private practice, representing people in both civil as well as criminal matters.
For how many years?
It was from 1997 up until 1998 when I was appointed, when I joined prosecution, the NPA.
Okay.
Right.
Continue, sir.
And over and above that, I'll exclude my experience as a district and regional prosecutor. Over and above my experience from private practice, I was a civil magistrate in the district court for a period of over 5 years, dealing with civil trials, dealing with motion roll, opposed and unopposed, and in Pretoria, in fact, I'll be sitting with plus minus 100 matters. As a district magistrate in Pretoria, you were obliged to deal with both opposed and unopposed matter. In other words, you first have to complete your unopposed matters. Then sometimes I'll sit until 6 p.m. in order to finalize my opposed matters. Then my third tie of civil experience, it was in the regional, it's in the regional court in Bloemfontein, where I'm dealing with the same civil matters as it was in Pretoria, dealing with civil trials, opposed and unopposed, dealing with divorces. In fact, I provide civil services to our outside courts, because in Bloemfontein, every regional magistrate has outside courts. So I'm sitting 2 days in Bloemfontein. I have a day in Dielsville. I have a day in Boshoff. I have a day in Rowville. In Rowville, I provide civil services to the indigent people who cannot travel 350 kilometers return from Rowville to Bloemfontein.
I think you would do well just to give us a sense. So you've done civil work quite frequently
Yes.
at the magistrates court level.
Yes, Honorable Chief Justice.
Okay.
Thank you, Chief Justice. Doctor, I don't profess to know everything in this world. What I do know, however, the practice of the law in the High Court differs from the practice of the law in the lower courts. Now, let me ask you another question, Doctor. Do you believe there is racism on the bench and in the profession in general?
Yes, I believe so.
Would you care to elaborate? Have you yourself personally experienced it? And if you were to be appointed, or if rather, were this commission to recommend you for a permanent appointment, what steps will you as an individual or collectively with the judiciary take to eradicate racism in the profession?
I believe racism is quite unfortunate that it still persists in our country. And I believe where racist behavior amounts to criminal conduct, it must be dealt with and punished severely.
Do you believe, finally, Doctor, you would benefit from an acting position rather than just going for a permanent position? I will tell you why. You have never acted in the High Court, and if you were recommended for a permanent appointment, that's a permanent position. Should you fail, anything can happen. Should you fail, the system will be stuck with you. So the best thing is to start acting somewhere, and if you are successful, then you could apply for a permanent appointment. Would you care to comment?
Honorable JP, I'm not opposed to your suggestion, but I believe I am adequately qualified, adequately experienced, and I promise Honorable Chief Justice as well as Honorable JP and this commission, as well as the people of the country, that I'll never fail you.
A promise, Doctor, finally is one thing, but the reality is that if you have not acted at all, and given that 65% of the work, particularly in Cape Town, where you have maritime law and so on, is in fact civil law, the chances are greater that should you be appointed to a permanent position, the chances are that you would want to learn on the bench. As a JP, you have an interest over the litigants.
I concur with you, Honorable JP, but my case is not a unique case. I'm not a first candidate to have been appointed permanently without acting experience. Hence, I referred to the JSC guidelines. The JSC guidelines does not provide acting experience as prerequisite.
Doctor, that may well be so, but for years now, that was the case before the JSC was structured. If you are referring to me, you are right. I was appointed in 1994. It was before the JSC was structured. There is a questionnaire here, and we encourage people to act before they are appointed.
I concur with you,
Thank you.
Honorable JP.
Thank you, Chief Justice.
Ms. Stewart?
Just a quick follow-up, Chief Justice.
Yes.
Doctor, what is the relevance of acting if people can just move from anywhere they move from directly into the bench?
Honorable Commissioner Malema, as I've indicated, that my case is not a unique case, that there were judges who were appointed before without acting experience. In fact, I have referred to JSC guidelines, and in my, besides JSC guidelines, in my case, I have an all-round experience. I represented litigants as an attorney.
I'm sorry, may I interrupt you?
All right.
The commissioner simply wants to know, would you say that it is of any consequence that people should act before they are appointed, or is it something that really doesn't matter? Just a direct answer
All right.
would help. If he needs more detail, he'll put further questions to you.
Thank you, Honorable Chief Justice. I believe it should depend from, it must be on case-to-case basis. It should depend on the merit of a candidate.
Thank you. Ms. Stewart?
Thank you, Chief Justice. I have two short questions. The first is, you said you've applied to 5 JPs for acting appointments.
Yes.
Did you get a response from any of those JPs?
I got response from 2. In fact, the JP of the Free State, it's my understanding, contacted my RCP, but what they do in the Free State, especially from the regional court, it's they will look at your colleagues who arrived before me in the Free State to give them that opportunity. I was in line, but because of there are other colleagues who were there before me, I know one colleague, he was my mentor, Mr. Rashid Matthews. He will be acting from October, from October. So
there's a possibility you will get to act when they get to your place in the queue, is that
Yes,
right?
yes.
Thank you. And the second question I have relates to one of your judgments. It's M versus M
Yes.
and the appeal. I want to read a quote which has been provided by one of the commentators to the applications. It says the regional magistrate did not give reasons for his decision. And then another quote, I'm not going to read the whole thing. The regional court president must consider this case as one pointing to lack of training or inadequate training on divorce matters and take steps to remedy this so that it should not be repeated. Can you tell me why you didn't give reasons for your decision and whether you agree with the suggestion that there's been a lack of training on your part in respect of divorce matters?
That's a very simple question to that. Rule 51.1 was not complied with. I can briefly refer to Rule 51. Rule 51 provides, I don't know whether I need to elaborate, Chief Justice.
No, she just wants to know, why did you not give reasons?
It was because Rule 51.1 was not complied with. It requires the appellant, before they note an appeal, to ask for reasons. That was never complied with. It was never brought to me that reasons were required in terms of Rule 51.1.
Thank you.
Thank you, Chief Justice.
Well, you are excused, sir.
Thank you.